This video is only meant to provide general legal information and is not legal advice. Before you take any action or rely on any information in this video, it is recommended that you consult an attorney or contact the Legal Aid Society of Hawaii. This video provides general information about private landlord-tenant rights and responsibilities. There are two different types of rental agreements: fixed or term leases and month-to-month leases. A fixed or term lease is a written contract between a landlord, a homeowner, and a tenant for a fixed period of time, usually 6 months or 1 year. A fixed or term lease ends the day it says it will end. No additional notice is required from the landlord or the tenant. Month-to-month agreements can be written or the result of an oral agreement between the landlord and the tenant. A month-to-month lease may be terminated at any time by the landlord by giving 45 days written notice, or the tenant by giving 28 days written notice. Neither party needs to be at fault to terminate or end the lease. When applying for a rental, landlords can charge a reasonable application fee. The fee is usually between $15 and $25. This includes the cost of credit check and processing the application. Landlords are not allowed to discriminate against prospective or potential renters because of their race, color, national origin, sex, disability, familial status, marital status, HIV infection, ancestry, gender identity or expression, or sexual orientation. These are considered protected classes by the Fair Housing Act. If you feel you have been discriminated against in violation of the Fair Housing Act, you may register a complaint against the landlord by calling the Legal Aid Society of Hawaii's Fair Housing Enforcement Program. Their number is 808-527-8024. Landlords may charge the tenant a security deposit. Security deposits are used to make sure the tenant fulfills the lease or agreement and leaves the dwelling in good condition. Landlords may also charge a pet security deposit that is equal to 1 month's rent. The pet security deposit is not applied to assistance animal. The landlord must return the security deposit minus any reasonable deductions within 14 days of the tenant vacating the premises. The landlord must notify in writing the reasons for any deductions. Costs must be itemized and copies of receipts included. If any repair to the unit are needed and cannot be done within 14 days, estimates for the cleaning or repair services may be substituted. The landlord may deduct any unpaid rent from the deposit. The following are examples of reasons for retaining all or part of the security deposit: any costs such as cleaning over and above normal wear and tear, damages to the premise over and above normal wear and tear, a list of specific repairs, and loss of revenue due to improper notice to vacate. Tenants should always pay rent on time and pay by check, cashier's check, or money order, and keep copies for their records. Tenants should ask for a receipt from their landlord if they pay in cash, and should never pay rent with cash without receiving a receipt. Repairs that a tenant requests from a landlord are emergency repairs, health and safety repairs, and general repairs. Emergency repair requests involve a major appliance, electrical, plumbing, or other necessary facility. The tenant may notify the landlord orally or in writing. The landlord must take steps to start the repairs within 3 business days. Health and safety repairs requests involve problems that are in violation of the applicable building laws and/or make the unit uninhabitable. The tenant must also notify the landlord in writing. The landlord must take steps to start the repairs within 5 business days. General repair requests involve a condition that is minor but needs repair. The landlord must take steps to begin the repairs within 12 business days. If the landlord is unable, for reasons beyond his or her control, to take steps to begin repairs as described, there is a good faith requirement that requires repairs will be completed as soon as possible. For emergency and general repairs, the landlord must notify the tenant of the reasons for the delay and set a reasonable tentative date on which the repairs will begin. If the landlord does not take the proper steps for repairs as described, the tenant may use a procedure known as repair and deduct. This means that the tenant may perform the repairs or have them done. The tenant must provide copies of all receipts to the landlord and may deduct the amount up to $500 from the next month's rent. No more than 3 months' rent may be deducted in a 6-month period. The tenant may not repair and deduct if the damage was caused by the tenant or someone living with the tenant or someone they allowed into their home. If the landlord does not make the necessary repairs within the 12 business days, the tenant may give the landlord 2 written estimates from qualified workers at least 5 days before repair work is scheduled to begin. The tenant may have necessary work done by the worker who provides the lower estimate. Then, the tenant must provide all receipts to the landlord and may deduct $500 or 1 month's rent, whichever is greater, from the next month's rent. The landlord is prohibited from doing any of the following. It is illegal for the landlord to attempt to recover possession of a dwelling unit by willfully interrupting or decreasing the availability of running water, hot water, or electric, gas, or other essential service to the tenant. This means the landlord cannot turn off the tenant's utilities. Again, this is illegal. If the landlord engages in illegal utility shut-off, he or she will be subject to a minimum penalty of 3 times the monthly rent or $1,000, whichever is greater. If the landlord removes or excludes the tenant from the premises overnight without cause or a court order, then the tenant may recover possession or terminate the rental agreement. This means the landlord cannot just lock out the tenant. The tenant can also recover an amount equal to 2 months' rent or free occupancy for 2 months and the cost of the suit, including reasonable attorney fees. However, if the court finds that the landlord was with cause or was authorized by a court order, the court may award the landlord the cost of the suit, including reasonable attorney fees. If the tenant complained to a governmental agency concerning conditions which violate health laws, or if the tenant has in good faith requested repairs or the landlord's compliance with any provision of the Landlord-Tenant Code, the landlord may not take any action to recover possession of the unit, increase rent, decrease any services related to the rental, or evict the tenant, as long as the tenant has paid and continues to pay the rent on time. This means the landlord cannot retaliate or seek revenge against the tenant for asking what the landlord follow the Landlord-Tenant Code or to complete repairs. The landlord does have certain rights. The landlord may demand rent payment any time after it is due. The landlord may notify the tenant in writing that unless payment is made within 5 business days after receipt of the notice, the rental agreement will be terminated. This is known as 5-day notice to quit. If the tenant does not pay the past due rent in full after receiving the landlord's notice, the landlord may file a complaint for summary possession in district court. The complaint must be served in person to the tenant. If this is not possible, the court can grant a motion to post the complaint on the tenant's door. In order to evict a tenant, the landlord must 1. Give proper notice, 2. File the complaint for summary possession in district court, 3. Serve the complaint on the tenant, 4. Have a return hearing, which is generally 5 days after service of the complaint, and 5. Have a trial if the tenant denies violation. The landlord also has certain obligations. The landlord must have the unit ready for the tenant to move in at the time and in the condition agreed upon. Provide a safe and healthy premises as required by law. Make all repairs and arrangements necessary to keep the premises in a livable condition. Maintain all electrical, plumbing, and other facilities in good working condition. Provide and maintain garbage bins and arrange for frequent removal of waste, except in the case of a single-family residence. Provide for the supplying of running water as reasonably required, except in the case where the building is specifically exempted by law. Tenants can avoid many problems by following these tips. Unless advised by an attorney, pay your rent and pay it on time. Even if the landlord violated an agreement, pay your rent on time. You can still be evicted if you withhold rent. Read your lease agreement before you sign a lease. Make sure you understand everything in the agreement. Do not sign if you don't agree with or understand any part of the lease. Notify your landlord immediately of any problems that arise. Tenants should keep rental units clean, dispose of garbage regularly, and keep common areas clean. Tenants should do a detailed move-in inspection inventory, such as taking pictures of the unit before move-in and noting the condition of the unit before move-in. Keep a copy and give a copy to the landlord. In addition, tenants and landlords should both keep good records. Take pictures of each area of the rental before moving in. Take pictures of anything damaged. Take pictures of any repairs. Keep a copy and record of all correspondence with your landlord or tenant. This includes copies of receipts for repairs, receipts for payment of rent, letters or emails notifying of repairs or problems with the rental unit. Please refer to the Landlord-Tenant Code directly for all details about rights and responsibilities of both the landlords and tenants in Hawaii. The code and other useful resources can be found online by visiting the Department of Commerce and Consumer Affairs of Hawaii website at www.cca.hawaii.gov. For other resources including legal information brochures, interactive interviews, see the additional information section below. Remember, this video is only meant to give general legal information and not to give specific legal advice. For more information, call Legal Aid Society of Hawaii at 808-536-4302 or visit www.legalaidhawaii.org.